This is a tutorial for personnel working in education about GDPR. The learning outcomes for this tutorial are twofold. To understand what GDPR means for people working in education, and to understand your obligations in relation to GDPR. Bear these in mind as you listen, and we will revisit them at the end to see how your knowledge has improved. GDPR stands for the General Data Protection Regulation. It is a legal framework that sets guidelines for the collection and processing of personal information from individuals who live in the European Union. On a basic level, the GDPR is designed as a direct replacement for the Data Protection Act, which was introduced in 1995 as a UK equivalent to the EU's 1995 Data Protection Derivative. On a basic level, the GDPR is designed as a direct replacement for the Data Protection Act, which was introduced in 1995 as a UK equivalent to the EU's 1995 Data Protection Directive. The Data Protection Act 2018 is the UK's implementation of the GDPR. This is UK legislation, and as such we all have a duty to comply with its directives. Under the Data Protection Act 2018, you have the right to find out what information the government and other organisations store about you. These include the right to be informed about how your data is being used, access personal data, have incorrect data updated, have data erased, stop or restrict the processing of your data, data portability, which is allowing you to get and reuse your data for different services, and object to how your data is processed in certain circumstances. You also have rights when an organisation is using your personal data for automated decision-making processes without human involvement, profiling, for example, to predict your behaviour or interests. GDPR principles are broadly similar to the Data Protection Act 1998. However, there are several key changes. There is no principle for individual rights. This is now dealt with separately in Chapter 3 of the GDPR. There is no principle for international transfers of personal data. This is now dealt with separately in Chapter 5 of the GDPR. There is a new accountability principle. This specifically requires you to take responsibility for complying with the principles and to have appropriate processes and records in place to demonstrate that you comply. There are 7 key principles in the GDPR. These are lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. These principles lie at the heart of the GDPR. They are set out at the start of the legislation and inform everything that follows. The principles don't give hard and fast rules. Rather, they embody the spirit of GDPR. There are very limited exceptions to these principles. These principles lie at the heart of the GDPR. They are set out at the start of the legislation and inform everything that follows. The principles don't give hard and fast rules, rather they embody the spirit of GDPR. there are very limited exceptions to these principles. GDPR is legislation, and as such, failure to comply can leave you open to substantial fines. For large companies, this can be 20 million euros or 4% of their annual turnover, whichever is higher. Let's think about some of the principles in more detail. First, let's take lawfulness. This principle says that you must have an appropriate lawful basis for data processing. You must not do anything unlawful with personal data. There must be a condition for processing data. For processing of personal data to be lawful, you need to identify specific grounds for the processing. This is called a lawful basis for processing, and there are 6 options which depend on your purpose and your relationship with the individual. There are also specific additional conditions for processing some especially sensitive types of data. Lawfulness also means that you don't do anything with the personal data which is unlawful in a more general sense. Now, let's look at fairness. Processing of personal data must always be fair as well as lawful. If any aspect of your processing is unfair, you will be in breach of this principle, even if you can show that you have a lawful basis for the processing. In general, fairness means that you should only handle personal data in ways that people would reasonably expect, and not use it in ways that have unjustified adverse effects on them. You need to stop and think not just about how you can use the personal data, but also about whether you should. Transparency is one of the simplest principles. Transparency is fundamentally linked to fairness. Transparent processing is about being clear, open and honest with people from the start about who you are and how and why you use their personal data. Transparency is always important, but especially in situations where individuals have a choice about whether they wish to enter into a relationship with you. If individuals know at the outset what you will use their information for, they will be able to make an informed decision about whether to enter into a relationship or perhaps to try to renegotiate the terms of that relationship. Under GDPR, there are 2 types of data: personal and sensitive. Personal data comprises any information that can help identify a person or their family. In school, college or training centre records, this would be their name, their address, their contact details, their disciplinary records, as well as their marks and progress reports. This sort of data remains personal, even if an individual chooses to publicise it. Sensitive data, on the other hand, includes students' biometric data, for example, fingerprints or photographs, religious beliefs, for example, a student's opting out of a religion class, health, which could be information about allergies or dietary requirements, which may hint at their religion or health. Data in the sensitive category may pose a risk to people, and hence can only be processed under certain conditions. So, how does the GDPR affect us in education? Well, this might be more widely than we would imagine. Do you have a work laptop that holds information about your learners, their achievements and progress, personal details, or any other type of information? You need to consider how you use and encrypt this information. For example, does your laptop have a suitable password and other security measures? How do you use your learners' data? Do you communicate with other professionals about them? Do you share details via email, and is this over a secure server? The GDPR highlights the importance of two roles, which can be either individuals or entities. There is a data controller who determines the means and purposes of processing data. Then there is the data processor, who handles the data on behalf of the controller. Each of these parties has different legal responsibilities. In education, the school, college or training centre will typically be the controller, so it has to secure a clear contract with the processor. A processor can take various forms, from a photographer to a shredding company, an online learning platform or a piece of software. Any operation these entities perform on data counts as processing, even if it's automated. This includes collecting it, storing it, retrieving it, destroying it, and so on. Can you think of any data processes you deal with in your place of work? A school, college, or training centre must appoint a data protection officer. This person will be dedicated to GDPR. Their job is to monitor policies, provide training, conduct audits, and more. But as individuals working within education, we shouldn't count on the data protection officer to discover all flaws in their system, and we all have a duty to monitor our own practice regularly. As part of your own self-monitoring, you could ask yourself, on what grounds am I processing data? What data is held, where and who has access to it? What security measures are in place and are they robust? You may need to change and update passwords regularly and ensure your emails all go through secure servers. Don't rely on others to ensure you are legally compliant with the GDPR. We also have a duty to inform ourselves about GDPR and keep up to date with any changes to the regulations. The websites on this slide could help you update and maintain your knowledge. Let's revisit those learning intentions from the beginning of the tutorial. You should now understand what GDPR means for you as someone who works in education. You should now understand your obligations in relation to GDPR. Let's revisit those learning intentions from the beginning of the tutorial. You should now understand what GDPR means for you as someone who works in education. You should now understand your obligations in relation to GDPR.